To be here with my colleague Katie McCrae. We are attorneys with the Wilson Turner Kosmo law firm here in San Diego. For those of you not familiar with us, we help businesses of all sizes with employment issues. So if you ever have any employment needs, such as litigation or just day-to-day advice regarding compliance with California employment laws, we are happy to assist. So today, Katie and I are going to discuss the laws and regulations that we believe have had the most significant impact on California employers in 2025. For more in-depth details, you can check out our law firm's October 2024 legislative report, where we have summarized all the new employment laws that took effect this year, as well as our annual checklist that provides guidance employers should consider taking for 2025. I believe Audrey provided those materials in the chat, but if you did not receive them, please let us know and we'll be happy to provide them. We're also going to be sharing some insights into the key employment related bills introduced in this year's legislative session. And I know Katie will put a plug in at the end of our presentation, but if you are interested in kind of keeping up to date on those pending bills, we recommend signing up for Wilson Turner Kosmo's legislative newsletter. In this newsletter, we break down the introduced bills, explain how they will impact California employers, and as well as track their progress through the legislature. In fact, our first newsletter was published yesterday, so be sure to check that out. And with that very brief introduction, I will hand it over to Katie to discuss the California wage and hour updates for 2025.
Thanks, Patty. Yeah, so we're going to start by talking about some of the laws that are already in effect, right? Key laws that went into effect on January 1st, or some of them went into effect even sooner. Hopefully these are already on your radar, but we wanted to focus on the few big laws that we think have the biggest impact this year that we want to make sure you're aware of and you're in compliance with. So one of the biggest new employment laws of the year actually went into effect back in July. So I'm sure it's at least on your radar. It's a substantial overhaul of PAGA. That's the Private Attorneys General Act of 2004. What's PAGA? I'm sure most of you know all too well, but it's a law in California that allows aggrieved employees to step into the shoes of the labor commissioner and recover penalties from employers for labor code violations. It allows employees to recover those penalties for themselves and also for other aggrieved employees. Now, the amendment to PAGA is a big law with a lot of detailed provisions. We're only going to do a high-level overview today, but definitely feel free to reach out to us if you have any more questions. The first big change for PAGA for this year is that there are some provisions that may limit the scope of PAGA cases and penalties going forward. In the past, if an employee could prove that they suffered a single labor code violation, they could represent all employees who suffered any labor code violation. So a claim by one employee could result in an incredibly broad case. But under the new law, an employee can only pursue a representative action in connection with labor code violations they suffered personally within the statute's 1-year statute of limitations. In addition, in the past, the California Supreme Court had held it didn't really matter how big or unwieldy or unmanageable a PAGA case was, aggrieved employees could still pursue it. But now courts have authority to limit the evidence presented and the scope of claims to ensure that claims can effectively be tried. Together, we think these two provisions may be useful in narrowing the scope of PAGA representative actions going forward. In addition, some penalties have been reduced. Under the old law, a violation of many labor code sections could lead to penalties of $100 for the first violation and $200 for subsequent violations. And a lot of plaintiffs' counsel interpreted that to mean that if you had a wage statement, if you issued 26 wage statements in the year and you had the same error on all 26, the first wage statement of the year was entitled to a penalty of $100, and the 25 subsequent wage statements were $200 penalties. The new law caps penalties for most violations at $100 per employee per pay period, unless the employer is engaged in egregious wrongdoing. So penalties are still steep, but arguably less than they were before. Now, this next slide has to do with what I personally think is one of the most significant changes to PAGA. The new amendments really encourage companies to try to comply with the labor code. This is something you can do proactively to try to limit the company's liability if you ever do face a PAGA claim. So the law says that if employers take all reasonable steps to comply with the labor code, they may face significantly reduced penalties. What does it mean to take all reasonable steps? Well, the law says this includes conducting periodic payroll audits, taking action in response to the results of the audits, disseminating lawful written policies, and training supervisors or taking corrective action with regard to supervisors. Now, let's say there's still a violation of the labor code. You took all reasonable steps before receiving a PAGA notice. Penalties will be capped at 15% of the normal amount. And companies that take all reasonable steps within 60 days after receiving a PAGA notice will have penalties capped at 30%. There's still a lot of uncertainty about how this is going to play out in practice. For example, we don't know precisely what's going to count as reasonable and how courts are going to view that. And there's a little bit of wait and see to see how this ends up playing out in practice. But in the meantime, I think this is a big reason to consider conducting a payroll audit to make sure you're always confirming that your policies are up to date and make sure you're training your supervisors about compliance with wage and hour laws. There's just a potential for a really significant reduction in PAGA exposure, even if, despite your best efforts, you can't avoid every single technical violation of the labor code. Finally, I wanted to just really briefly mention that the new PAGA amendments expand employers' ability to cure violations of the labor code and thus escape claims altogether. But the definition of cure is extremely onerous. It's something you definitely want to discuss with counsel if you become aware of a labor code violation and you're considering paying back pay, or you receive a PAGA notice. Sure, that's more than enough PAGA for today for everyone. I'm sure you're on top of this, but a quick reminder about some changes to the minimum wage. The statewide minimum wage is now $16.50 per hour. That means the threshold for the white collar exemptions is now higher. It's up to $68,640 per year in California. The computer professional exemption salary threshold also increased this year. You can see the numbers up on the slide. And of course, many local minimum wages have also increased. Here in San Diego, the minimum wage is now $17.25 an hour. It's just a good reminder to always check for all of the city and county level minimum wages that might be applicable to your business. UC Berkeley posts a comprehensive list on its website that I think is helpful, just a good resource. They keep that up to date. You can find a link to that in the checklist that was circulated with the materials for today's program. Also, a reminder for those in the healthcare space, hopefully you know this and are on top of it, but the healthcare minimum wage went into effect on October 16th with a pretty short turnaround time. And it covers all workers in covered healthcare facilities, which includes way more than folks who are involved just in directly in patient care. There are also a bunch of different levels of minimum wage based on facility type and different dates of implementation. So definitely want to make sure you're on top of that if it applies to your business. And finally, as I'm sure you know, California has a fast food minimum wage. It's $20 per hour. The Fast Food Council is currently considering a proposal to increase that to $20.70 per hour. They haven't made a final decision on that, but you certainly want to keep an eye on that if it affects your business.
Thanks, Katie. So we're now going to turn off the latest updates on the laws related to time off, leave, and accommodations. One of the biggest updates in California's leave requirements was the expansion of the Victims of Violence Leave Law under AB 2499. Previously, California law offered protections for employees needing time off for jury duty, court appearances, or if they were victims of crime or abuse. These protections included prohibiting discrimination or retaliation for taking such time off. Employers also had to reasonably accommodate employee victims to ensure their safety at work, including the implementation of safety measures such as a transfer, reassignment, or modified schedule, among other accommodations. Additionally, employers were to inform employees of their victim rights upon hire or request. The new law expanded these protections for employees in 4 main ways. First, AB 2499 has now broadened the category of victims. Previously, employees could take time off if they were the victims of crime or abuse. The new law replaces crime or abuse with the term qualifying act of violence. What is a qualifying act of violence? It includes domestic violence, sexual assault, stalking, or any conduct, act, or pattern of conduct that causes bodily injury or death, involves a dangerous weapon, or includes threats to use force to cause injury or death. Now, this is regardless of whether anyone was actually arrested, prosecuted, or convicted of committing a qualifying act of violence. Second, these leave protections now extend to employees whose family members are victims of a qualifying act. This is a major change, as under the previous law, employees could only take leave if they themselves were the victims. Third, for employers with 25 or more employees, the reasons for taking time off have expanded. Now, employees can also use this time to seek or obtain medical attention, psychological counseling, support services, legal services or relief, such as obtaining restraining orders, and to ensure the safety and welfare of the employee victim or their family members who are a victim. Finally, the previous law allowed employees to use vacation, personal leave, or other compensatory time off, while the new law has also lets employees use paid sick leave for any of that time taken. Now, while the new law significantly expanded who can take leave and for what reasons, it's important to note that the right to leave is not unlimited. Employers can set limits on the total amount of leave taken for the new leave purposes, depending on whether the victim is the employee or the employee's family member. If the victim is the employee, the employer can limit the total leave taken to 12 weeks. If the victim is the employee's family member, the employer can limit the total leave taken to 10 days or to just 5 days if the leave is being taken for relocation purposes. However, if the family member has passed away due to a qualifying act of violence, employers cannot limit the leave to less than 12 weeks. This leave also runs concurrently with any leave under the FMLA and CFRA if the employee is otherwise eligible. And while the new law is not clear on whether these time limits are per year or some other standard, the safest approach for employers is to provide this leave each year on either a fixed or rolling calendar year basis. In addition to the expansion on employee protections, the new law also expanded employer obligations in two key ways. First, employers must now reasonably accommodate both employee victims and employees whose family members are victims to ensure safety while at work. AB 2499 also specifically includes allowing employees to carry a phone at work as a reasonable accommodation. However, employers are not required to provide reasonable accommodations if the employee has not disclosed their or their family member's status as a victim. Second, besides notifying employees of their victim rights at hire and upon request, employers must now also provide this notice annually and anytime they become aware that the employee or the employee's family member is a victim. While this law took effect on January 1st of this year, the notice obligation won't kick in until the Civil Rights Department publishes the form notice, which is due on July 1st, 2025. So if you haven't done so already, which I assume most people have, I would recommend updating your handbooks and policies, as well as educating those who manage employee leaves on these expanded victim of violence protections. The next law changed how employees can use their paid family leave. So previously, employers could require employees to use up to 2 weeks of their accrued vacation time prior to and as a condition of the employee accessing paid family leave benefits. AB 2123 changed this. Employers can no longer make employees use their vacation time before accessing paid family leave benefits. This means employees now have the flexibility to decide when and how to use their vacation time in conjunction with their paid family leave time. Again, you might need to update your handbook or written leave policy to reflect this change if you have not done so already. So stepping away from that time off leave and accommodations topic, we're going to explore the two main changes that occurred in the harassment, discrimination, and retaliation space. SB 1137 is the prohibition on intersectional discrimination and harassment. Now, this sounds complicated, but it's really not. You're all familiar with existing law, which prohibits discrimination on or harassment based on defined protected characteristics. This law merely amended the statutory language under the FEHA, the UNRRA Act, and the Education Code to make clear that the law prohibits discrimination not only because of one protected trait, but also the combination of those characteristics. In 2022, California enacted the Crown Act. CROWN stands for Create a Respectful and Open World for Natural Hair, and it was designed to provide protection from discrimination based on hairstyle and hair texture under the FEHA and the California Education Code. This law amended the existing definition of race in those provisions to eliminate the requirement that a trait must be historically associated with race for it to be protected from racial discrimination. Now, it's important to note that this amendment impacted not only employers, but those businesses that offer services or accommodations to the public. So this means that covered businesses are prohibited from discriminating against any person based on race, including traits associated with race, such as hair texture and protective hairstyles like braids, locks, and twists. Both the prohibition on intersectional discrimination and the expansion of the Crown Act are very minor changes. However, if you haven't done so already, again, you might want to look at your handbooks, tweak them, the discrimination harassment section, so they are consistent with this law.
Awesome. Thanks, Patty. We had a question come in, Patty, about the change to the paid family leave benefit law. And the question is whether state benefits will be available immediately or whether there will still be a 2-week waiting period. My understanding, do you know the answer to that question off the top of your head, Patty?
I'm not off the top of my head, but I can look into that.
Yeah, my understanding, Megan, who asked the question, is that there was no change in the waiting period for availability of the state benefits. So if an employee wants to choose to use their, accrued vacation during that waiting period, you might allow them to do so. But we'll try to confirm that. But I don't think there was any change in the waiting period rule. Okay, the main point of this new rule is that you can't require someone to use their vacation time before they use the state paid benefits. Okay, we're going to move on to some new laws regarding human resources and human resources policies. The first was entitled the California Worker Freedom from Employer Intimidation Act. It prohibits employers from holding captive audience meetings. What's a captive audience meeting? It's an employer-sponsored meeting where the employer communicates its views and opinions about religious or political matters, notably including the topic of union representation. And with the passing of this law, California became the 10th state to ban these meetings. However, the law was almost immediately challenged in 2 lawsuits that claim it infringes on employers' free speech rights and is otherwise preempted by the Federal National Labor Relations Act. Now, those lawsuits seek an injunction blocking enforcement of the law, but to my knowledge, the court hasn't yet taken action. So if you're contemplating holding such a meeting and requiring employee attendance, definitely want to check with counsel about the status of those cases and sort of stay tuned for further developments. You probably know that California law has various tests to determine whether a worker is an independent contractor or an employee, and that if a worker is an independent contractor, companies don't need to comply with various rules that are applicable to employees like the minimum wage, overtime, et cetera. Now, there's a new law. This new law doesn't change the test for independent contractors, but it adds some statutory protections for certain independent contractors. So the law calls these workers freelance workers. They're defined as independent contractors who provide certain professional services as defined in Labor Code Section 2778B for at least $250. Now that test for whether you satisfy that test to be an independent contractor under Section 2778B is super complicated. We're not going to get into the details today, but it does involve some marketing, HR, travel agent, graphic design, and fine arts work, among others. So let's assume you're hiring someone to do work for your company. It does meet this test to be an independent contractor under this specific section, and you're going to pay that worker at least $250. The new law requires you to do a few things. First, you need to have a contract in writing. You need to provide a signed copy to the worker, and you need to keep a copy of that contract for 4 years. And then there are a bunch of specific terms that have to be included in the contract, including an itemized list of all of the services to be provided, the value of those services, and the rate and method of compensation. You also have to list the date on which compensation will be paid or how you're going to determine the pay date. Next, you need to actually pay the worker on the date specified in the contract. And finally, once the worker starts performing services, you can't require the worker to accept less compensation than was specified in the contract, or require them to provide more goods and services or grant more intellectual property rights than they agreed in the contract, unless you jointly amend the contract, okay? The new law also creates a private right of action for workers to enforce the law and creates penalties and liquidated damages for violation. So the key here is just, if you do hire independent contractors, you want to check and see if they fall in this category. And if so, make sure you're papering that agreement in the correct way. This next law amends FEHA, the Fair Employment and Housing Act, and makes it unlawful for employers to state in a job advertising, posting, application, or other material that an applicant must have a driver's license, unless the employer reasonably expects driving to be one of the functions of the position, and the employer reasonably believes that satisfying the job function using an alternate form of transportation, such as biking, walking, or using a ride-hailing service, wouldn't be comparable in travel time or cost to the employer. So if you haven't already, you should review your job postings, your job descriptions, and your application materials, and make sure you can satisfy this new standard if you're stating that a driver's license is required.
We, of course, cannot talk legislative updates without discussing the latest Cal OSHA related update. Now, this is a little stale as this went into effect on July 23rd, 2024, so about 8 months ago. But California has a new indoor heat illness prevention regulation, and this is aimed to protect workers from heat-related illnesses in the indoor workplaces, such as restaurants, warehouses, and manufacturing facilities where temperatures can get dangerously high. So this new regulation applies to indoor workplaces where temperatures reach 82 degrees Fahrenheit or higher. When temperatures reach 82 degrees, employers need to take steps to protect employees from heat illness. Now, these steps include providing cool down areas where temperatures are kept below 82 degrees, providing fresh, cool drinking water, allowing employees to take cool down rest breaks as needed, and training employees on the risk of heat illness, the importance of hydration, recognizing symptoms, and knowing emergency response procedures. There are also additional requirements when the indoor temperatures reach 87 degrees or higher. Where temperatures reach 87 degrees, employers need to implement engineering controls such as ventilation, air conditioning, and cooling fans. Now, if these engineering controls are not feasible, employers must implement administrative controls such as rotating employees, rescheduling work to cooler times of the day, reducing work intensity, and monitoring the indoor temperature and heat index. Additionally, if employees wear clothing that restricts heat removal or work in high radiant heat areas, those additional requirements apply at the 82-degree standard.
Great, thank you, Patty. All right, now we are moving into the realm of looking off towards the horizon, pulling out our crystal ball a little bit, and talking about what might happen this year. So we are at the very beginning of the 2025 legislative session, where the California legislature is considering bills that might go into effect next year. California has a pretty transparent schedule for the introduction and passage of legislation. So we have a pretty good idea of when we should be learning more concrete information about the laws that are to come. So we've already passed the first deadline, February 21st. That was the deadline to introduce bills. So that means we have a pretty good idea of the bills that will be up for debate this year. There's a slight caveat there. The senators and assembly members have the ability to introduce spot bills. These are kind of placeholder bills that say, I'm planning to introduce a bill on a certain subject. And as long as they get that in by February 21st, they can amend that to have something more substantive, so long as they make that amendment by March 26th. Of course, even after bills have been introduced, they can be amended. Sometimes they change a little, sometimes they change a lot. But we at least by now have a decent idea of sort of what's on the agenda for this year. Of course, the next step is that bills actually have to pass. They first have to pass the policy committees to which they've been assigned by May 9th. Then they have to pass the House in which they were introduced by June 6th. And they have to pass the other House by September 12th. Anything that doesn't meet one of those deadlines has effectively failed for the year. If it doesn't pass committee, it's out for this year. So at each of those deadlines, we should get a slightly narrowing set of bills that are still on the table. And then finally, on October 12th, that's the deadline for Governor Newsom to either sign or veto all the bills that have been passed by the legislature. So today, knowing that we're dealing with preliminary information, we wanted to give you just a heads up about the key bills that have been introduced. The final caveat, we're tracking more than 50 employment-related bills and an additional 15 or so spot bills that seem to relate to employment. But today we're only going to highlight the top dozen or so that we think would have the broadest impact on California employers if they do end up passing. We organize these like loosely by subject, but it's not necessarily in order of importance or significance. And as Patty mentioned at the very beginning, yesterday we published our first legislative newsletter of the year that has summaries of all 50 plus of those employment-related bills. So if you're just a sucker for that kind of thing, please read our full newsletter.
Yeah. So there's a couple bills that are pending in the harassment, discrimination, and retaliation sector, but there's only really one that we think is relevant and significant so far, and that is AB 1015. So as everyone is aware, California law requires employers to provide harassment training to employees within 6 months of hiring or promotion, with refresher training every 2 years. However, this can be challenging for employees who frequently change jobs, as they might have to repeat the training even if they've just completed it with a previous employer. So the aim of 1015 is to amend this by allowing employers to accept a certificate of training of completion from the past 2 years, regardless of where the employee actually received the training. So an employee, if you received the training at your previous job and then a month before you started your new job, that employer can now use that certificate for those next 2 years. This change is basically to simplify the process and reduce redundancy to ensure employees don't have to repeat this training unnecessarily.
All right, there are a couple of bills potentially related to human resources and workplace policies that we wanted to highlight. The first, AB 1331, I think has the potential to be extremely significant if it progresses. It would impose broad new regulations on the use of workplace surveillance tools. This bill defines that to include any systems, applications, instruments, or devices that collect worker data, activities, communication, actions, biometrics, or behaviors. And the bill specifies that this includes both video and audio surveillance, electronic workpiece tracking, geolocation, electromagnetic tracking, and more. The bill would prohibit employers from using any of these workplace surveillance tools to monitor or surveil workers in private off-duty areas. But it defines that pretty broadly to include not just bathrooms, locker rooms, changing areas, and lactation spaces, but also cafeterias, break rooms, lounges, and smoking areas. So that means if you let employees smoke on the loading dock out back and you've got a camera, a security camera that goes over that loading dock, you wouldn't be allowed to surveil them while they were on smoke break. The bill would also prohibit employers from monitoring or surveilling a worker's residence or personal vehicle unless that surveillance is strictly necessary. Now, there's no guidance as to exactly what that means, particularly with respect to, say, a worker who works remotely from their residence. I suppose we will have to wait and see if any further guidance is provided in any amendments. Finally, the bill would require employers to disable workplace surveillance tools during off-duty hours, and that's defined to include rest and meal break periods. So again, to the extent there's any surveillance in place or monitoring, you wouldn't be able to keep that going or turned on while someone was taking their rest break or their meal period. This is far broader as than existing restrictions on workplace surveillance, so we'll definitely be monitoring it closely. And then there's a related bill that didn't even make it on the slide, but I actually think is also super important, so I wanted to mention it. This is AB 1355. It's a bill that would significantly restrict the use of location data. Now, it's not limited to employers or the employment context, but as drafted, it appears to apply to employers because the bill would apply to just about any individual or business in California that uses or collects location data, except state or local agencies. And it would define location information as information that reveals the geographic location of an individual or a device within the state of California within a range of 5 miles. The bill specifies that this includes IP addresses, GPS coordinates, and cell site location information, as well as several other things that don't appear as relevant to employers. But I'm sure that y'all know, it would be hard for me to imagine that there's anyone on this call who doesn't at least track IP address used by workers. So this bill would impose a bunch of obligations on covered entities, that is all businesses except the state, that collect or use location data. First, covered entities would be prohibited from collecting or using location information unless, one, doing so is necessary to provide goods or services requested by the individual, and two, the individual has expressly opted in to the collection or use of their location information for that purpose. It is not clear how that requirement, that data be necessary to provide goods and services, would apply to data collected or used by employers with respect to their employees. And who knows, maybe in future amendments that will be employers will be carved out. I'm not holding my breath, but we'll have to wait and see what happens with that. But again, an interesting thought experiment. And then notably, under this bill, it's not enough to provide advance notice or even provide an ability to opt out, which is basically what's already included in the CCPA, if that's something that covers you. Individuals would have to affirmatively opt in to the collection or use of their location data. The bill would also make it unlawful to collect more precise location information than is necessary, to retain it longer than necessary, to sell, rent, or trade it, to disclose it to third parties. And it would also require covered entities to prominently display notice stating that location data is being collected and to have a location privacy policy, including very specific information. Under the bill, violations of the law would be subject to a claim for damages and a civil penalty of $25,000. So between the location information bill and the workplace surveillance bill, some important things to track in terms of employee monitoring. That was a lot to say on one slide. I got one more thing to talk about. There's a bill that would affect rehiring and retention rights of workers displaced by natural disasters. Now, ever since 2021, COVID, employers in the hospitality and business services industry, employees in those industry who were laid off for reasons related to COVID-19 have certain rehire and retention rights. That law is set to expire December 31st of this year. This bill would extend the protections of this law to employees who were laid off for a reason related to a natural disaster, including a wildfire, flood, tsunami, mudslide, landslide, earthquake, atmospheric river, tornado, lightning, extreme weather event, or other economic, non-disciplinary reason related to a natural disaster, if they were laid off on or after January 1st, 2025. Now, the bill would also create a presumption that a separation due to lack of business or a reduction in force is due to a reason related to a natural disaster, unless the employer establishes otherwise by a preponderance of the evidence. If enacted, this new bill would remain in effect until December 31st, 2031. Now, the new bill would apply to the same employers as the existing law: hotels, private clubs, event centers, airport hospitality operations, building services, If you're covered, I assume you know, right? Because you're already covered by the protections for layoffs related to COVID-19. The new bill would provide the same substantive protections to laid off employees. It would have the same enforcement mechanisms. The only thing it would do is change the definition of laid off employee. So as of January 1st, 2026, the statute would no longer protect employees laid off due to COVID-19. Instead, it would protect those who are laid off due to a natural disaster. And as I sort of hinted earlier, the bill would have something of a retroactive effect because it would apply to employees who are laid off going back to January 1st of 2025. All right, a few more potential human resources workplace policies bills. First has to do with what needs to go in a personnel file. You all know you have an obligation to retain certain personnel files, certain personnel records. You know that employees have the right to inspect and receive a copy of those records. This bill would expand that law to provide that employees have a right to inspect their education and training materials. It would also specify that employers who maintain education and training materials have to keep very specific records, including the name of the employee, the name of the trainer, the duration and date of the training, the core competencies of the training, and the resulting certification or qualification. And finally, there is a bill that would effectively make it unlawful for employers to enter into stay or pay agreements. These are agreements by which employees are obligated to pay a certain amount of money if their employment terminates. A very common example is when an employer says, I'll pay for this employment or training program, but if an employee quits within 2 years, they have to pay back the training costs. This bill would create a new section in the Business and Professions Code. That's this in the section of the law that regulates restraints on trade and non-competes. The new law would apply to contracts entered into on or after January 1st, 2026. So it's not going to invalidate old contracts, but it would put restrictions on contracts you could enter into going forward. Okay. It would make it unlawful to include a term in an employment contract that requires a worker to pay money after their employment ends, including costs associated with a job training program or skills training program, or any necessary expenditure or loss that was incurred in direct consequence of the discharge of their work duties, including training, residency, orientation, licensure, or competency validation required by the employer. I'm sure you can know this would be a very significant change. Now, existing law already invalidates any contracts by which anyone is restrained from engaging in a lawful trade, and it makes it unlawful to require an employee to enter into a non-compete agreement. This new law would provide that a stay or pay agreement, as we just talked about, is an unlawful restraint on trade. And it would also add a section to the labor code giving the labor commissioner authority to enforce the law in the Business and Professions Code against restraints on trade, including non-competes and stay or pay agreements. And it would allow injured parties to recover actual damages or $5,000, whichever is greater. This is significant because the current law against non-competes allows employees or wronged persons to recover their actual damages. But if they can't prove they had any actual damages or those are very small, there's nothing they can recover. This new law would effectively create like a $5,000 penalty for entering into those illegal contracts. That's all I've got for workplace policies, at least so far. I bet you're glad.
So unlike the human resources topic, there's only one significant pending Cal OSHA bill, which is actually AB 1371, not AB 1372 as the slide says. So I apologize for that typo. So AB 1371 would modify existing workplace safety laws under the Cal OSHA Health Act of 1973. This act already requires employers to follow specific safety and health standards and prohibits them from firing employees who refuse to perform work that violates these standards and creates a clear hazard. This new bill would expand those protections by allowing employees to refuse tasks if they reasonably believe that performing the task could result in injury or illness to themselves or to others, even if the task does not explicitly break safety rules. The employees must communicate their concerns to the employer, and if the employer fails to address them, the employee can refuse the task and still receive full wages until the hazardous condition is resolved, or the employee can reasonably conclude that the task no longer poses a risk. Additionally, this bill would protect employees from disciplinary action and retaliation for refusing hazardous tasks. However, it does narrow the scope of who is covered by removing domestic work employees from the definition of employee.
Okay, there are a couple of bills that have potentially significant impacts in the wage and hour space. So first, I'm sure you all remember that back in 2022, California enacted a law that required all employers to provide the pay scale for a position to an applicant upon reasonable request, and required employers with 15 or more employees to post the pay scale within any job posting, and to provide that pay scale to any third party who's engaged to announce or post a job posting. This bill would amend that law. I'll be honest, it's rather awkwardly phrased, but I think it's trying to place limits on how broad the posted pay scale can be. Now, I know a lot of employers struggled with defining the pay scale when this requirement went into place, and some have very, very broad ranges. The bill would require that, quote, the pay scale provided in any job posting shall be no more than 10% above or below the mean pay rate within the salary or hourly wage range, end quote. I think this bill is trying to say that the pay scale in a job posting needs to be within 10% above or below the mean pay rate for the position. So if the mean pay rate for the position is $50,000 a year, the posted pay scale couldn't be broader than $45,000 to $55,000. I think I did the math right on that. But that seems potentially problematic to me, since some jobs legitimately have much broader pay scales. But I think we're just gonna have to wait and see what happens with this. But I think this is a significant one to track, just in case it does change that obligation on all employers with more than 15 employees. The bill would also make some changes to California's pay equity law. So this is the law that says it's unlawful for one employee to be paid less than another employee of a different sex unless certain specific requirements are met. This bill would expand the statute of limitations for bringing such claims and would make it easier to bring a claim based on a continuing violation theory. It would also clarify that wage includes all forms of pay, including salary, overtime, bonuses, stock, profit sharing, life insurance, vacation and holiday pay, reimbursement for travel expenses, and benefits. So if you're assessing whether one employee has been paid a wage rate less than employees of another sex, courts would consider all of these forms of pay in making that determination. The next bill would also make changes to a relatively new law. SB 464 would make changes to the pay data reporting statute. So the existing law was enacted in 2020. It's already been amended once in 2022. It requires private employers with 100 or more employees or 100 or more labor contractor employees to submit annual pay data reports to the Civil Rights Department, including mean and median hourly rates for employees within each combination of race, ethnicity, and sex within each job category at each work establishment. This bill would expand that law in several ways. First, it would expand its reach to include public employers with 100 or more employees. Well, that's interesting. Second, it would require that employers collect and store any of this demographic data separately from employees' personnel records. Third, it would require employers to report on sexual orientation, but only if employees voluntarily disclose that. And fourth, it would allow the CRD to publish private employer data reports, provided that the publication is reasonably calculated to prevent the association of any data with any individual person. As I read it, this might allow disclosure of the name of the employer, just not disclosure of individual employee information. We'll have to see if that gets clarified, but that would be a significant change from the current law, which only allows the CRD to publish aggregate data based on the results of the reports it receives.
And so, depending on your feelings, I'm either saving the best for last or the worst for last, which is artificial intelligence in the workplace. Me, this is the worst. So, over the past few years, the California Civil Rights Council and the California State Legislature have been actively working to regulate the use of artificial intelligence, better known as AI, in employment-related decisions. This year is no exception. So in late January 2025, the Civil Rights Council issued its most recent version of proposed modified regulations to address potential discrimination in employment decisions resulting from the use of AI and automated decision-making systems, which are commonly known as ADS. Some key highlights of these proposed regulations, which have changed multiple times since their introduction in, I believe, May of 2024, includes clarifying that existing anti-discrimination laws, such as FEHA, apply to discrimination caused by the use of AI and ADSs in hiring, promotions, and other employment practices. Employers must ensure that AI and ADSs do not perpetuate bias based on protected characteristics such as race, gender, and age. To achieve this, the regulations mandate human oversight and regular audits of AI systems to detect and mitigate any discriminatory outcomes. Some specific guidelines are provided for the use of AI in background checks and medical or psychological inquiries, ensuring compliance with California's anti-discrimination laws. Additionally, employers are responsible for any discriminatory practices resulting from the use of these AI tools, even if those tools are developed and managed by external vendors. The proposed regulations also specify that anti-bias testing or other similar protective efforts to avoid unlawful discrimination will be relevant to any defense that an employer may make based off of this alleged discrimination. And one final notable aspect of these proposed regulations is that it would extend the period for which personnel or other employment records must be preserved from 2 years to 4 years, and would include all automated decision system data in that preservation requirement. Now, I've had clients say that this is not a big deal because they just don't use AI or ADSs in connection with applicants and their employees. But many employers are surprised to hear the scope of what's considered an automated decision-making system. For example, in addition to the more commonly thought of examples, such as screening resumes for terms or patterns, these regulations would also include computer-based tests, puzzles, or games that make predictive assessments about an applicant or employee, that measure dexterity, personality traits, or other abilities and characteristics, or that analyze facial expressions and word choice. So we're just going to have to wait to see what happens with these proposed regulations, but it is important to be aware that these new rules may be coming even as early as this year. And as Katie previously mentioned, we are currently tracking 50 employment-related bills. 6 of those are AI bills, plus 2 spot bills, which have the potential to impose significant new requirements on employers who use AI or ADSs to facilitate those employment-related decisions. So I want to talk first about SB 7 and AB 1018. I know that they're last on the slide, but they're probably the most important ones for employers to be aware of. So SB 7 has been nicknamed the No Robo Bosses Act, and this would mandate strict guidelines for employers using ADSs in employment-related decisions. Under this bill, employers would have several new obligations. Employers cannot use ADSs that would violate federal, state, labor, or civil rights laws or infer sensitive personal information. Employers cannot rely solely on an ADS for making critical employment decisions such as hiring, promotion, discipline, or termination, and a human reviewer must corroborate these decisions with additional information like supervisory evaluations or personnel files. Employers would also be required to provide a written notice to workers when an ADS is used for employment-related decisions. This notice must be clear, in plain language, and provided via a simple method such as email. Employers would need to give a pre-use notice at least 30 days prior to introducing the ADS, as well as a post-use notice when the decisions are communicated to the workers. Workers would have the right to appeal these ADS-based decisions, and employers must respond to such appeals within 14 business days. Employers who violate the provisions can face civil penalties up to $500 per violation. And AB 1018, while similarly aims to regulate the development and deployment of ADSs, it covers a much broader area of critical sectors beyond employment, such as housing, healthcare, among others. And I also think there's like utilities, like essential utilities. So AB 1018 would require developers of ADSs to conduct performance evaluations to ensure that their systems are accurate, fair, and free from bias. These evaluations must be provided to users of the ADSs, defined in the bill as deployers, who are responsible for using the ADS in their operations. Deployers would be required to disclose the use of ADSs to these affected individuals, offering them the option to opt out of ADS-driven decisions, with some exceptions not applicable to employment decisions, as well as the ability to appeal decisions made by the ADS. Deployers would also be required to submit their ADS to third-party audits to verify compliance with performance standards and ethical guidelines. Penalties would be imposed for non-compliance, including fines up to $25,000 per violation and potential legal action. Developers, deployers, and auditors would be required to provide unredacted performance evaluations to the Attorney General upon request, further ensuring accountability. By mandating these measures, AB 1018 is seeking to protect individuals from potential bias and errors in automated decision-making processes, ensuring that these systems are used responsibly and ethically. Now, that's a lot for both of those bills, but I just don't know the likelihood of SB 7 or AB 1018 passing. Similar bills have been introduced in the 2023 and 2024 legislative sessions, but they all failed. But there is obviously a clear interest in regulating the use of AI in the employment-related decisions. And the other remaining AI bills have a little bit more of a generic application to them. So AB 316, this seeks to enhance accountability for the use of AI by prohibiting developers and users from claiming that the harm caused by AI was due to the AI's autonomous actions. This would mean that developers and users of AI systems cannot use the defense that the AI acted independently to avoid liability for damages. This bill would also build on existing laws that require AI developers to document the data used to train their systems and make this information publicly available. SB 366 is very simple. It just basically would mandate a comprehensive study to assess how AI affects worker well-being, job quality, job types, different populations, and state revenues. The study would aim to provide insights into the benefits and risks associated with the use of generative AI in the workplace. SB 420 aims to safeguard against potential harms such as discrimination, privacy violations, and unchecked automation in critical decision-making processes. This bill outlines several key rights for individuals, including the right to clear explanations of AI operations, control over personal data with informed consent, and protection against discrimination. It would also mandate regular audits to address biases, ensure accountability for harm caused by AI, and provide a transparent process for seeking redress, including human oversight for significant decisions in areas like employment, healthcare, housing, education, and criminal justice, among others. And finally, SB 468 builds upon the California Consumer Privacy Act of 2018, as well as the California Privacy Rights Act of 2020. So this bill would require businesses deploying high-risk AI systems to implement a comprehensive information security program. These programs must include administrative, technical, and physical safeguards to protect personal information. Violations would be considered deceptive trade practices and subjecting businesses to penalties. And the bill would also empower the California Privacy Protection Agency to adopt regulations and enforce these provisions, aiming to enhance data privacy and security in the digital age. So, as you can see, there are quite a few AI bills on the horizon. Um, Given the lack of federal regulations and the rapidly evolving AI landscape, we're just going to have to wait and see how these bills develop this year. However, when examining the proposed regulations and the proposed bills, there are several common themes that emerge that we can anticipate being included in AI legislation that it will eventually become law. First, employers will be prohibited from using AI or ADSs that result in discriminatory impact. Second, there's a clear emphasis on testing or verifying these systems so they do not perpetuate discrimination. Third, there will likely be requirements for notifying individuals when AI or ADSs are being used. Fourth, provisions for opting out or appealing decisions made by these systems will most likely be included. And finally, human oversight will most likely be mandated to ensure there's fairness and accountability with these AI systems. So we have a lot to look forward to in AI in the workplace.
Thank you, Patty. That was a masterful summary. Okay, that's it. We only have 2 minutes left. If anyone has any questions, we'd be happy to answer them. And I would also be happy to stick around for an extra few minutes if anyone does have any questions. You can pop those in the chat or even take yourself off mute. But while we're waiting to see if anyone has any questions, I'll just remind you or first of all, thank you for attending and sitting through that hour. It was a ton of information. We hope there were some useful tidbits, both about what's already the law and what we're looking forward to potentially becoming law in 2026. And if you do want to receive our legislative newsletters to track these bills right alongside us as the year progresses, just drop me an email. My contact information is here. And of course, don't hesitate to reach out to me or Patty or any of our colleagues at WTK about any of these issues we covered today or any other issue about compliance with California law. So I will stick around for a couple more minutes if anyone wants to drop a question in the chat, but otherwise, thank you so much and enjoy the rest of your day.
Thank you.